Greetings, Justice Seekers. Welcome to Justice, Not Justice, Season 1, Episode 23. All right, so we have a hearing, our last hearing on December 31, 2018 in front of Judge Richard Sankovitz, which was the day that he was retiring from his duty. It's a very lengthy order, so I'm going to try to summarize and skip through some of the pieces. Like many who appear in family court without a lawyer, Mr. Collins is unfamiliar with the procedures we usually follow. On the other hand, very, very few other unrepresented parties have heaped so many requests on the court in such a short period of time. Mr. Collins has not been patient. He says, so again, none of this was acted on. So if you don't hear anything about something and or you have a hearing and it's ignored, you have to bring it up again. I mean, this is an issue that gets brought up in a lot of other different ways moving forward. So that's why this is important. Mr. Collins does not seem to appreciate the number of other cases pending court and the limited time the court can give to piecemeal requests for the court to take action. Nor does he appreciate that the more requests he makes without giving the opportunity for the court to hear and decide the motions already on file, the longer it will take the court to resolve the disputes because of the torrent of requests. Now, again, remember the use of words. The person that we're dealing with, which is Jeremiah, who doesn't understand what half this language means. If it weren't for me, he would be completely oblivious to what this even means. But these are the words and the tone that the judge chooses to take. And again, we have to ask ourselves why. And I have already made the criticism of the court that it is extremely unfortunate that it doesn't have the time to properly understand circumstances and situations in order to make rulings and orders which have significant legal consequences, which Lisa Bangert likes to continue to refer to, that she's threatening hanging over his head, that she's going to, she's going to follow through on those contempt things. So, all right. So some changes in the structure, new judge, we already know. A request was filed to substitute for a new judge. Was received and approved. So basically, we're supposed to have a hearing on the 7th, and somehow that ended up getting kicked off. That's kind of a little bit of an aside. And then Jamie's lawyer has withdrawn. Kristen Reedster may not represent Mr. Collins. We have already discussed this, and that I am not attempting to represent him, but that he has a disability, and a reasonable accommodation to satisfy his disability is to have somebody who has an intellect and a vocabulary on par with the other parties, attorneys and judges namely. But they want to talk about how I'm not a lawyer and that to do so would be in violation of all these statutes and Supreme Court things and blah, 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 which is, again, not the issue. Mr. Collins certainly needs the advice of a lawyer, and we've already tried to state to the judge that he already paid $4,000, doesn't have any more money for an attorney, and look what that $4,000 got him, which was basically a representation in front of this judge that, in fact, what Bangert and Jamie said about him was true. So John was definitely not doing his job and was doing more harm than good. Okay, whether or not become clear. Okay, the court there's hostility. The court might need to decide some things. We suggested this and that. Okay, the findings issued by the Family Court Commissioner on December 11 present a more current and therefore more accurate summary of the issues that need to be resolved in order to finalize a divorce in this case. So we're going to have to, have some of the motions by Mr. Collins heard by the court, blah, blah, blah. Okay. And we asked that Ms. Collins be held in contempt for serving late responses to her discovery, for failing to notarize, and They contained false statements, and they were scheduled to be heard in front of the family court commissioner, because that's what we were told was supposed to happen. But the family court commissioner does not have the authority to resolve these issues. So all of his motions for contempt must be denied, because there were a bunch of rules and procedures that weren't followed. So again, I'm going to say that it is incumbent upon the court, specifically in Wisconsin statutes or some such thing related to Milwaukee County courts, whether it's a rule or an administrative specific thing to Wisconsin or to Milwaukee County, that judges and the court are told that they need to help people who are representing themselves. And I'm not going to talk about that again, because we've already talked about it, but it is actually in an official document. And so for the judge to be suggesting that we have to do all of these things because Mr. Collins did it wrong. I mean, to a certain degree, I understand that, he can't give legal advice or whatever, but by the same token, can you summarily just dismiss important issues because the procedure wasn't followed correctly? Okay. And I almost believe that we did follow the procedure correctly based on history and previous experiences and things like that. But instead, just denied. Regarding the motion asking the court to remove the guardian ad litem. On October 22nd, we asked for that. We filed for it again on December 13th because it's not being addressed. And in any hearings that may have happened during then, wasn't dealt with. Okay. So regarding the allegations about her lying and being biased, he doesn't provide any evidence, and no details, and so therefore must be denied. But we already said in a previous video that in fact he did provide details and specific examples, which apparently just chose to pretend that they didn't ever get those. Okay. Mr. Collins has filed numerous documents along with his motion, and these would be the details and examples that he just said we have to deny this because of. However, parties are not permitted to heap a pile of documents on the court and expect the court to sort through them in an attempt to fashion an argument for the parties. Why would you even say that? It was very clear in everything that we uploaded that this is in support of, this is in support of. You have to look at things that are uploaded to this. How else are you going to know anything if you don't actually look at what is being uploaded to the file? Okay. I mean, evidence is evidence. And as I've said before, and I will say it again, it's probably already becoming very clear that never, ever, ever, never, ever, ever, never in any of the hearings with any of the people in any of these in front of an official person was any of this evidence ever allowed to be introduced, discussed, considered. None of it, ever, okay? Even though we attempted multiple times to have evidence introduced and things like that. Never. So how is the court running without evidence? That's what blows my mind, and it appears to be happening. And I just read another story about another issue here in Milwaukee related to the protests, that's exactly what happened. They just took people's word and made decisions. How can you do that? I mean, isn't the whole point of evidence? Okay, more about the So he says that when time permits, time never permits. That's why we send it to you in advance so that when we come to these hearings, you already know things, because at the hearing itself, there's never time for anything. But when time permits, the court will hear all of the evidence that is relevant. But he just said that there wasn't any evidence provided. So in the meantime, the guardian ad litem has not engaged in any conduct before the court, which suggests that she cannot or will not be an impartial, objective, and zealous advocate for the best interests of the children. What do you think about that? Do you think that that's correct and accurate? So then we talked about how she has spent an inordinate amount. And I forgot to mention that, so 78% of the time talking to Jamie and her people and 22% talking to Jeremiah. That includes 1 hour at the very beginning spent with all 4 children. She doesn't talk to the kids. She talks to mom and mom's friends. What do you think mom's friends are going to be saying? The amount of time guardian ad litem spends talking to each of the parties is no measure of favoritism. The court is much more concerned about the content of the communications rather than the length of the communications. Really? And what is the content then? Because that's never been delineated in any of the invoices or anything like that. Further, to the extent that the time spent by the GAL speaking with Mr. Collins is limited, and this may be explained better by his hostility toward her, not by bias. He has every reason to be hostile toward her, and she is hostile toward him. I mean, the bias is so clear here, right? I mean, it's just so clear. I don't even have to talk about it. Mr. Collins should be prepared to explain why a GAL would be biased against him. If there is no reason for the guardian ad litem to be biased, is she related to Ms. Collins? Does she stand to gain anything from Mr. Collins by favoring Ms. Collins? Is there any extraneous factor that makes her predisposed to work against Collins? Right. Why? Is it because he's black? Is it because he's a male? If not, then it is unlikely that the court can conclude that the guardian ad litem is biased. Okay. Then we're trying to talk about, that she hadn't paid the mortgage. Now we're several $1,000s behind, and, he didn't do it right, apparently, even though I don't think that that's correct. Mr. Collins should understand that the mere filing, so he says, I'm going to go into foreclosure. So here's how the judge responds to that. Mr. Collins should understand that the mere filing of a foreclosure action does not create an emergency which requires the court to hear such a motion on an expedited basis. Foreclosure proceedings take enough time to permit the court in divorce proceedings like this to resolve disputes between the parties about their mutual and individual responsibilities to preserve marital assets, such as the equity in a home they may own. Okay, so again, you're used to dealing apparently with wealthy people, because when you have a hard time making the mortgage payment anyway, and now all of a sudden you're several $1,000s behind and it goes into foreclosure, the only way to catch up is to repay that money. So let's say ultimately it's $30,000, which it ended up being pretty close to that by the time this was all said and done. And theoretically you split that. So he's supposed to come up with $15,000 to bring it out of it, and she's supposed to come up with, it doesn't work like that, and he knows this. So it is an emergency, because every $750 that goes behind gets added to interest and attorney's fees and all kinds of things. If Mr. Collins' concern in raising this motion is about preserving his share of the equity in the house, and again, there's no equity. We've already established this for months. Then he should maybe make the payments. Okay, so he should make her mortgage payments, which she has been court ordered to do, as well as he should pay the rent on the new place that he has to have because he was kicked out of his house. How is he going to be affording to do this? Why aren't we talking about the fact that Jamie's not making the mortgage payment? Why are we focusing on Jeremiah? Why? Okay, we're almost done here. The orders, status conference on January 14. Mr. Collins' request for an order to show cause, denied. Request for blah, denied. Request for payment of mortgage, denied. Request of the denied. Assigned to the Honorable Judge Jane Carroll. I'll see you soon.